She also states in this submission, and as I said, we have received quite a number of submissions and heard witnesses about talk to us about the appalling behaviour of RMS in relation to compulsory acquisition. But she does say that basically the house was acquired in the settlement. It was agreed that in September 2017 we would become tenants and pay rent for our former home. A rental price was agreed of $550 per week. Just prior to commencement of rental payments, the acquisitions officer contacted my husband and we were informed that the RMS were increasing the rent to $600 per week, an increase of $200 per month. Does that sound reasonable to you?
So we'd have to take the detail of that on notice.
This is consistent with a number of submissions we've received.
So what I would say, so what the policy, what the government policy on compulsory acquisitions is that where we, or voluntary acquisitions, by the way, is where we have acquired somebody's property and that transaction occurs before we need that property. If they want to stay in the property and we have an ability to let them stay in the property because we don't need it quite yet, we do allow them to rent it back at market rent, and those market rents are assessed.
When you said it was voluntary, sorry, can you explain the word voluntary when you said voluntary acquisitions then?
So whether it's, I'll correct, whether it's by agreement or compulsory. So whether it's an acquisition by agreement or whether it's a compulsory acquisition.
Yes, hard. Yeah.
Then the policy about rental is the same, which is that where we can accommodate it, we do, but it's at market rent.
Do you think it's quite a heartless decision, really, to put a family through all of this, and they've agreed to $550 per week, and for some reason RMS comes back and said, "Hang on, we've made a mistake. We're going to up it by $50 a week"?
I think what I've said is I'll take the specifics of that on notice. I mean, I don't know the detail of the circumstance that you're referring to. I'm very happy to take it on notice. I'm very happy to provide a full response.
We've heard from families as well that they haven't had their full bond refunded, even though their house was going to be demolished. The RMS was not going to provide a full bond in refund because there were, something wrong with the inside of the house, even though the houses were going to be demolished. Multiple stories in relation to that.
I'm not aware of that, but I'm happy to take the detail and deal with it, Mr. Drover.
Another one is, it sounds like you're going to have to take all the details on notice. I'll put another one before you if you like. So this is in relation to a property acquisition in St Peters, again, $70,000 below market value. RMS failed to stick to their deadlines of making an offer as well as paying the agreed amount. This led to me not receiving the final payment until after the 2nd of July 2016. People haven't received their payment. Once you compulsorily acquire these properties through all of the pain and agony, these people are saying that they then don't even receive their payment on the due date.
While I'm happy to take that on notice, the requirement.
Point of order. Chair, there's been a constant stream of interjection and muttering from the gallery. Can you remind members there to remain absolutely quiet during these proceedings, or else you'll clear the chamber?
They've been very quiet, in my opinion.
Well, I can hear a continual stream of muttering, including bullshit from one particular person continually over and over and over again. And it's offensive to the witnesses and it's disruptive to the proceedings. So I ask you to remind them again what their responsibilities are.
I speak to the point of order, Mr. Chair. I'm hearing it as well, and it does intimidate the witness. I'm sure the witness can stand up for himself, but I think it's disrespectful to the process.
We need to let the witnesses give their answers. They're here at our request to help our inquiry.
So just so we understand the payment process, so if a property does go into compulsory acquisition, we're in fact required to pay 90% of that before the value is determined and before the property is actually purchased. We actually pay 90% of that value at that time. That's what we're required. That's what we're required to do. While I'm happy to take the detail on notice,
yes, and
I would be very surprised So our
If you could take
requirement.
on notice
our
how
requirement,
many properties that relates to in terms of final payments or the initial payment and the final payment, both sets of payments you're referring to, with all of the properties that you've compulsorily acquired, if they've been on the due date.
I'm very happy to do
Or
that.
not.
As I'm very happy to do that. If it goes through compulsory acquisition, there's a very clear legal process, and if it's done by agreement, then there's obviously a binding contract. I'll be very surprised if we haven't made payments on the due date, but I'm very happy to investigate any individual circumstances.
Thanks.
The witness will need to have the addresses of those properties so they can investigate it.